Okay, continuing on with Standard 6. So this is the last of the standards that we need to cover. And we're dealing with conflicts of interest. So very important one again. And this first one, Standard 6A, is disclosure of conflicts. The thing that we need to always remember is to disclose all relationships that may either influence our decision-making process or where we may have some sort of benefit, financial benefit, but not necessarily financial. So again, it's just easier that everything is disclosed. So for instance, if there was an investment banking or a family, personal, intercorporate stock holding, agent options, additional compensation, board directorships, personal relationships, and fee deals. You know, there's some examples of the types of things that we may need to disclose so that people, our employer is aware of any conflicts, and our clients as well. Best practice is to request stock to be assigned to another analyst with no conflict. So this is the case where you are employed to do analysis of a particular company, and you may own a sizable number of shares in that company. Well, obviously, there's a conflict of interest there. So it's best that if you would speak to your supervisor and say, I can't look at this stock, I can't have an opinion on this stock because I have a large holding in it. And hopefully there's someone else that can. If you did, there was no one else available and you did have to have an opinion and write research on it, well then you would definitely have to disclose that in any sort of research papers, etc. that you created. Disclose changes in compensation arrangements that may cause conflicts. So that's really thinking about everything that you do and looking at it from the point of view of, could this unduly influence my opinion or the work that I do? And if so, then yes, this is a conflict that needs to be brought to my employer/compliance officer's attention. So a question here, an analyst has been covering a particular firm for years. Recently, the analyst's uncle died and left the analyst a sizable position in the firm's stock. The analyst needs to A, sell the stock and donate the proceeds to a charitable organisation. No, that's not what the standard says. Do nothing, since the analyst did not purchase the stock and receive the stock indirectly. Well, no, that's not right either, because there's still a conflict now. C, refuse to receive the stock in the first place. Again, not a requirement of the standard. There's nothing to say that you can't receive the stock, only that you need to disclose. And then D, disclose the ownership of the stock to his supervisor. Well, obviously that is the most appropriate action in this situation. Moving on to Standard 6B, priority of transactions. We've touched on this a couple of times in market manipulation and putting clients first. So again, that can be where this can be a little confusing, because this type of topic has been covered a couple of times, and you may be concerned about a question coming up saying which standard addresses this part of this scenario. Don't worry about that. The questions aren't there to trick you, like where you would pick duty to clients instead of priority to transactions. It should be pretty obvious which one it's going to be. So they're very careful about that. It's not trying to trip you up on purpose. Rather, the exam's there trying to make sure that you do know these standards and you understand the principles behind them. So a couple of points here: priority transactions, clients first, firm second, personal account last. Just remember that. Think of it again as far as these standards go. It's duties to clients, duties to employer, and then you come last out of that list. Fee-paying family accounts treated equally to other fee-paying accounts. We've talked about that before. Clients must be given adequate time to react to recommendations before the firm or your personal trading can be executed. So a question along these lines. Tim Burr, CMT, is an equity analyst for a regional investment firm based in North Carolina. Based on extensive research and his prior tenure on the board of a competitor, Mr. Burr has determined that JB Barbecue Restaurants Inc. is an excellent investment and purchases some of JB for his personal account. He then recommends JB to his largest clients by phone and to his other clients by email. With respect to the codes and standards, how would Mr. Burr's actions be best described? A. Mr. Burr has violated standard 6B, priority of transactions. Well, it's pretty hard to do sample questions like this when I'm focused on a section like section 6B right now. That's obviously the answer here. But anyway, let's look at the other ones. Standard 3B, fair dealing. Well, there's nothing really to say there that there's a breach of fair dealing. 2A, material non-public information. Nothing. He's just said he's done research, extensive research. The prior tenure could be an issue, but if the question was really going down that way, it would have been more specific about that. Would have really highlighted about internal information and an internal report that Mr. Burr had access to, something like that. And then D, there's no evidence that he's violated any standards. Obviously, because this is the section we're talking about, he's violated standard 6B, priority of transactions, because he bought the shares for his own account before recommending it to his clients. Another little point there, it makes this interesting comment that he calls his largest clients by phone and emails everyone else. That's okay if the largest clients are segmented as a different class of client. That can be because they're paying more fees, or it can be just by the size of their investment. So there can be that difference in the way that those clients are communicated with. That's okay, so long as the two groups are different classes. Where the standard comes into a issue here is if all clients were similar, there was no distinction between them, but let's say Mr. Burr decided to call one client first before emailing everybody else. That then would be a problem. All right, our last section here, Standard 6C, referral fees. Disclose prior to entering the agreement is the first point here. Make sure that if there's any referral fees, so you've got a client coming, but you're going to earn a referral fee, or you paid a referral fee for that client, then make sure that client is aware of that. Fees may be non-monetary, so it can be in lieu of some sort of other fee or services, exchange of services or barter. Also applies to internal firm arrangements, so within different branches of a company or a bank. Fully disclosed arrangements okay, though regulator may prohibit some type of fees. So again, this is that case where the stricter law, so the standards say that, okay, referral fees are fine, and so long as they're fully disclosed to the clients, but in some jurisdictions the regulator may prohibit them, and so obviously then you would have to abide by that. All right, so our question here, lease a car, CFA CMT, leases office space to her best friend War and Peace. Carr is a independent investment advisor specialising in high net worth clients, and Peace is a licensed real estate broker. In lieu of paying rent, Peace refers his real estate clients to Carr, but only with the client's permission. So the clients know about the relationship and are happy to be referred. For clients referred by Peace, what must Carr do? A, must disclose the terms of the lease arrangement. B, need not disclose the terms of the lease arrangement because Peace obtained the client's permission for the referral. Sounds reasonable. C, must disclose the terms of the lease arrangement only if required by state real estate law. Well, no, we're going by the standard here. Need not disclose the referral fee if Peace discloses the lease arrangement to the clients first. So because the referral fee is the lease arrangement, see, even though Peace got the permission to pass the details on to Carr, That doesn't mean that Peace told them that by doing this he was getting free rent. So we can't assume that the clients actually know about the terms of the lease arrangement. So A is the answer here. CAR must disclose the terms of the lease arrangement. It can't work on the assumption that Peace did disclose that correctly, and so would always have to let that client know before that client signed on with CAR. And that is the end of Standard 6. So again, thank you very much for taking the time to look at these videos on ethics, a very important topic. I hope this has definitely been beneficial to you in your studies, but also to help you as you prepare to be a professional, work as a professional in the finance industry. Please do check out our other Optima courses for CMT, for Quant, and obviously a number of growing topics as we keep researching ourselves and adding more courses into our library. Thank you.